Today, I'm going to share my screen and we're going to talk about ways to protect ourselves using reporting letters. And so hopefully everybody can see my screen and off we go. So, I've mentioned this before about how LawPro, when you open a file because you're defending a lawyer in a wills case, they ask about two things. One, was there a written retainer? And two, was there a reporting letter? And those are both, my argument today would be that those are both documents that are really easy to create and are useful and help the situation. And I would encourage people to do that. So what I'm going to run through here are the topics that I think that should be covered in the reporting letter. And on the right is a sample reporting letter. So we can sort of compare the two. So the first issue are issues of location and safekeeping. And the original document is so crucial, obviously, with wills. We all know that. Unlike any other document where copies are fine and copies are basically the same as an original, for a will, it's the original that matters. And so where that original is crucial, because the rule, of course, if you can't find the original will and it was last known to be in the possession of the testator, even if you can find 50 copies, it is presumed that that will was revoked. And so that's a real problem. So one of the things that we want to cover is where is the original? So in our reporting letter, you want to cover, okay, are we holding the originals or is the lawyer or is the client holding the originals? And I prefer generally to return the originals, but whatever your practice is, I think it's important to document it, because often we have this issue of the lawyer can't find the original will, even though it looks like they kept it and then they can't find it. Well, at least if we have evidence that it was kept by the lawyer, then we can prove a lost will. And so that's important. So dealing with that is important. Safekeeping, and sort of where the importance of safekeeping is also what we try to talk about in this reporting letter. The risks of losing it, because most clients don't recognize that, oh yeah, if I lose it, well, no problem. You have a copy, right? They always ask you, do you have a copy? Yeah, I've got a copy, but that's not going to help. And so, just reinforcing the importance of the originals being kept in a safe place wherever they might be, in a safe deposit box or elsewhere. And then I have this little suggestion that I throw in, that if the client ever just misplaces or loses the original, or not sure where it is, I put this little clause in there that says, if you ever just do that, do me a favor, send me an email or let someone know that you may have lost it, but you did not intend to revoke it. And that email is the evidence that could be used to rebut the presumption that it was intentionally destroyed. So imagine if you have an email from the testator that you can file with your application to prove the lost will, and it says, look, I lost it and I didn't mean to revoke it. That is pretty good evidence until they re-sign it. And then just a recommendation that you let the executors know where they might find the original will, because even if you preserve that original will and they have the best safe place to keep it, and it's brilliant, I'm going to keep it between my mattresses. Well, that's all great, but if the executor can't find it, then it's of no use. So those are the location and safekeeping issues. And just to address the issue, if we're holding certain copies, I'd put that in the reporting letter as well. So the next thing is the idea of review. And what I would typically recommend is that they review the will regularly, every few years, but also certain triggers to reviewing the will, like life changes vis-a-vis the beneficiaries. So death of a beneficiary, disability, incapacity, change of citizenship or residency, receipt of government assistance. So those are all the kinds of situations that should prompt a client to review their will. That's then on the testator side. So that's if that happens to any of the beneficiaries. But on the testator side, if they get married, obviously crucial, right? Separation, divorce, birth or adoption of children, significant acquisition or disposition of assets, a change of residency or citizenship. So those are just warnings. I put that in there just to remind the client that these are the triggers, but not also, half the purpose of this reporting letter or more is to protect you. So, if something happens and the client, doesn't change their will and say, I never knew that I had to change my will if I got married. If you don't have a reporting letter that says that, and that's the great thing about these reporting letters, in 99% of the cases, they're exactly the same. They're pretty standard. I'll show you where they change per client, but most of the content is pretty much the same. And it's better protection than not having it. Is it perfect? Of course, nothing is perfect, but it's pretty good. So the next thing is, what do we do about changes in the law? So one of the things that I would recommend is that we put in our reporting letters that the planning that we've given and our discussions and our advice is based on current law. Same with this letter. And if there is a change in law, that could affect your will. So who is then responsible for advising of changes of the will? So either you're going to say, look, we will advise you of major changes. I don't do that. And our reporting letter doesn't say that. Instead, it says the opposite. I say, if laws change, you should review it. But we're not assuming responsibility for that. And we're not going to tell you of that. And so why don't you contact us every couple of years and see if there's anything that requires changes. So those are the elements to try to cover off arguments that, well, my will's out of date and I thought you were going to tell me. And so, of course, the client dies and then somebody says, oh, you should have told my mom that, you could use multiple wills. Well, this will was done in 1987. Well, why didn't you tell? So those kinds of things. The next issue is amendments to the will. So I was involved early in my career on a case where it was a pretty big estate, and the client wrote "canceled" on the front of the will and initialed it. And that caused all kinds of mayhem. And in the event, we resolved it through litigation. But one of the things I would put in my reporting letter is that, don't write on your will thinking that's going to make a change. Because as we know, an alteration to a will has to be done in the same manner as a will is executed, with witnesses and all of those things. So scratching something out and initialing it, and anybody who's been in practice for any period of time, I'm sure has come across that, where the clients have written notes on the original will, say, not this, cross this out, initialed it, and think, great. That's not valid. And so all that does is cause mayhem. So don't do that. If you want to make a change, I say to the client, make sure that you go to a lawyer and do that. So the other things that I point out are that wills are always revocable. So if you think that this will is, and many clients do think that, that wills can't be changed. Wills can always be changed, as we all know. And so I just want them to know that. And if I'm acting for spouses, I want them to know that their spouse could change it without telling them, and vice versa. Then I also talk about, look, you might make precatory memorandum about personal effects, for example. Keep it with the will, right? And because, you could have a precatory memorandum, but nobody knows where it is. So if it's you want to do that. And the last kind of point is, and this is something that eState does automatically, if you've used a hodgepodge clause and included one of the options in a hodgepodge clause is to include future amounts, for example. The reporting letter will say to the client in that situation, you're to keep track of any future advances that you want to make sure that you document them and those kinds of things. So it's an automatic reminder based on the provisions of the plan. Another example is the where eState recognizes, oh, you've got a legacy to be paid on the first death. So you're acting for a couple, and it says, oh, I've got a legacy being paid on the first death. There's a reminder here to them that you better make sure that you hold assets that aren't joint in order to satisfy those legacies and the costs of the legacies and all of those things. So those are some what I call dynamic changes based on the plan that you've provided for the client, because you wouldn't necessarily have that warning unless they're actually making an initial gift on the first death. And I just want to see where we've got. Yeah, so let me just skip to this one for a second. So this is asset information. One of the things that lawyers get sued for in this area, the number one, is inadequate investigation. Unlike any other area of law, that's the number one cause of claims. And asset information is one of those key ones. And rarely do we have every piece of scrap of paper regarding every asset. And so one of the things that I put in there is that, I'm relying on the information that you've given me, and I have not independently verified, value, account numbers, policy numbers, legal description, manner of ownership. I put that in there. And because, if I got sued, if I did something and it turns out, look, I didn't do a title search and something was wrong, or it turns out they didn't actually own this or that, is this going to save me? I'd rather have this than not have this. I said, look, I didn't verify this. And by the way, that might not work properly if I don't verify it. So that's just a point there. Ownership right is crucial. Some of the issues about acting for both spouses to be addressed in the reporting letter are things like confirming that it's a joint retainer and that nothing's going to be confidential. I can't act for one of you in the future without the consent of the other or some other event like divorce, death. And I think really what's causes most problems is this idea of a potential mutual will. And so what I want to confirm is that, this is not a mutual will. They're revocable. You can change it. And, they're free to do that. And I've given you, options about using a trust, for example, or a domestic contract to mitigate against that. What happens when I generate a reporting letter from eState is that it looks at the disposition of the residue and says, oh, here's an absolute gift of 100%. Well, we better put in this warning about, the effect of the absolute gift and the fact that we talked about options, about trusts and other ways of dealing with things. So now we deal with a big one, which is foreign advice. And, the first thing that we want to address is the client or their spouse a U.S. person? If so, that may raise complications. So right now, the U.S. estate tax is significant, a threshold is very high. So you've got to have, like, for a married couple, you have to have like $11 million US. So that won't catch many people. But with the Democratic control of Congress and the presidency, we may see, an easy way to raise money is to lower the estate tax threshold so that now it would kick in at a lower number. That's quite possible. And so I like to warn any U.S. citizen clients that there might be U.S. estate tax. So if you have concerns about that, better contact and retain a U.S. Advisor to see if we need to do anything special. Are any of the beneficiaries U.S. residents or citizens? Because that might raise issues for them. Do you have foreign assets? Crucial, because if especially foreign land is going to be governed by the jurisdiction of the land. So if they own, for example, land in Greece, Greece might not, and in fact doesn't, I don't believe, recognize wills except in certain circumstances with respect to land. So, if we're doing this will and the client is saying, I guess I'm willing my Greek land away because that's what my will says. I want to make clear that, foreign assets are governed by foreign law, and this is a problem. And then saying, I'm not retained to and permitted or qualified to give you advice on foreign succession or foreign income tax laws and how they might affect your estate and your beneficiaries. And if you've got concerns about that, then I'm recommending that you reach out to a lawyer in that jurisdiction to determine whether any special advice is necessary. And then I'd like to close off with something that says, look, notwithstanding this advice, you're prepared to go without additional foreign advice. So that's the next thing. Oops. Let me just go down to the next set of slides. And that is income tax. So one of the things I don't do, and if you do, you can deal with this differently, but I don't provide income tax planning advice. So I try to scope that out of my retainer and recommend that you see a tax specialist if you are concerned about income tax planning advice. Now, what they might say to you, and Law Pro might, says, look, you can't, you're expected to know something about tax when you plan a will, and the fact that you give an RSP to a non-spouse, and then, that you're expected to be able to advise the client on that. So what I just talk about is really not excluding any reference to income tax, but I don't give income tax planning advice. So, take this and then do this with this. And I don't do that. So that's what I kind of suggest on that front. Then we deal with registered plan assets. So, RSPs, TFSAs, and if we're including them in the will, then what I typically say is, oops, sorry, there we go. That, they're only applicable, the designation in the will is only applicable to the specific RSPs that are in place at the time the will is signed, right? So it's unlike the other assets that are automatically covered by the will. For an RSP designation, it's only the RSP that is in existence at the time the will is made. I talk about transferring, purchase, and conversions are not covered. I suggest reviewing them as frequently as the will. And I also remind them about the tax, generally the tax burden, because what happened, they could go out and then change their RSP designation, and I didn't realize that it was going to trigger tax on my estate. So I just give them that general warning. So if it's not going to be included, then confirmation that you're not doing it, either because they don't have registered assets or they're satisfied with the current designations. And again, eState's reporting letter will look at the assets of the client and the spouse and look at whether there were designations included, and if there were, deal with it or not. And then, reminding them that there might be some benefit to designating a beneficiary, but you might want to review that from time to time. So that's that. Oops, I'm stuck over here. And similarly for insurance declarations. So I have a provision in there, which is basically the same as your RSP designations, but reminds a couple of things. One is that you should probably give a copy of the declaration to the insurance company so that they can update their records. But also, and this again is looked at if you're doing a spousal trust or something like that, and there's corporately owned insurance, reminding them that that can cause some issues when it flows out as a dividend, as to the definition of whether that is capital or income for the purposes of the spousal trust. So that's that. And again, some of these you might not see because they in the reporting letter that I've generated through eState, the client didn't have these issues, so they're not appearing. And that's the good thing about technology, is it puts in the right clause provisions if necessary. The next one is the idea of multiple wills. So in this case, what I typically would do is discuss highlight that we've discussed it, and then are we going with a single will? And if so, you may want to review this down the road, or if you have any questions, feel free to reach out to me. If we're using multiple wills, I want to explain sort of why we did it, and what could happen that might still result in probate tax being paid, such as changes to the law, a will challenge, or the executor just deciding to probate the secondary will for protection or other reasons. So, and the last thing that we're going to cover is children, and basically three issues. One, the idea of that you've named guardians, and that's applicable for this period of time, and recommending that you might want to leave a letter about upbringing and values and things like that. And then if you are excluding children born out of wedlock, for example, confirming that that's what's done in the will, or not, including them, whatever works. And of course that, eState would recognize which option you pick there and put in the right clause. And similarly for posthumously conceived children, whether they're going to be included or excluded. Just because we've seen cases where, there's a child who's born and would normally be included or would normally be excluded, but for the terms of the will. And then everyone says, well, the client never knew that, and I just like to have that confirmed. So that is basically the reporting letter vis-a-vis the will. And, for powers of attorney, we have additional provisions in there, our explanations of how they work and things like that. But that's that. And like I said, the reporting letters, are generated just the way you generate any document through eState. You click on it, you pick how you're delivering it, whether you did multiple wills, whether you did it included in a an RSP designation, who's holding the originals, is it delivered to the client or held by the firm, and how many copies if you do multiple powers of attorney. And then you just click that, and it generates a Word document that if it does need any editing, you can do that. You can paste it onto your letterhead. And at least for now, that's what we've got. So you can pick your font and all of those things, and it'll generate the escrow agreements if you're holding assets or documents in your firm's safe, and those kinds of things. So just generates it just like that. And again, it's looking at all the data to figure out what clauses to put in and what not to put in. So in a matter of seconds, really, you have, I think, pretty good protection, for most of the typical issues that somebody might complain about. So I'd like to open the floor up to the participants. I see we've got a number of people, and if anybody wants to post a question on the chat line, we can answer some of them. Yeah, so Teresa raises the question about using Notice Connect's will registry. Yes, great idea, a great product that if you're not familiar with that, basically you can register the will, the location of the will, and for your clients. So if either they're holding it or you're holding it, and then people, when they're searching, rather than those OR notices, you could search on Notice Connect's will registry, and if there is a matching person, then the person holding the document gets notified. So the lawyer who's holding it gets notified and says, "Oh, someone's looking for this will." And so it's a great system, and one day we'll probably integrate with them as far as eState goes. Bill raises the idea of notarial copies of the will and copies of the powers of attorney. Sure, good idea. The only problem is a notarial copy of the will is just a copy. So it's not an original, but could be helpful. If you ever needed to prove it, at least you've got a notarial copy. And multiple copies of powers of attorney are quite common. I don't do them much now while doing everything remotely, but they are pretty common. And that's why, for example, eState has options when you generate the reporting letter to, where are the copies? We're giving one copy to the client or 4 copies to the client and 1 held by the firm, and you can do that, and the reporting letter will take that into account. So Jane raises the point about in accordance with your instructions, you haven't verified the assets. Typically, I would say that when I'm going through the assets with the client. So, for example, here's Claire, and we're looking at the assets. One of the things I always say to them is like, okay, here are your assets. Is this everything? And I send them the list of the assets just so they can confirm. I would just say here, look, I'm not, I just want you to know I'm not independently verifying the CIBC savings account and the balance. I'm just going to go with these rough numbers. That's what I typically do. And that's when I do that. What else do we have? Comment about, yes, the U.S. estate tax going up. Other questions? We've got a couple more minutes. There's a question about mutual will contracts. I think I've spoken about that before. I'm not a fan of that. I think what they are is a domestic contract and needs to be really well thought out. There's a whole bunch of issues that need to be considered, and it's not just, oh, the survivor shall not change their will. That is not a good bit of planning, in my view. And if that's the intention, better think through it very carefully. And I believe that I've spoken on that at one of these webinars about that concept and how it should be approached. So I think we have that on video somewhere.
Jordy, can I ask a quick question?
Sure.
Sorry, it takes me too long to type this.
Yeah, sure.
I have been getting more frequent requests to do separate documents. I don't know what's happening out there, but I feel like I've been approached a handful of times, more often than I have in the past, with people just like, I just want to do my will, or can you just do my powers of attorney for me? And I'm personally not comfortable with that. I feel like it's a package deal, and I feel like the sort of due diligence that you would have to do to prepare either of these documents sort of would entail really having to give advice on the whole kit and caboodle. So I'm really hesitant to take on a retainer that separates them out, or where someone's just asking me for a one-off power of attorney for property. That one especially gets my back up. I don't take them on. I just wanted to get, because of your level of experience, I just wondered if I'm being overly cautious, or if there are situations where you might do them separately. And the only reason I could think of is if it's an ongoing client of my own that I know really well, and they simply need to adjust something in a document, but I wouldn't want to do it for a brand new retainer. Right.
So, yeah, I mean, I basically just make it too expensive for somebody to just do their power of attorney with me. That's how I deal with it. I don't like doing that either, but I mean, you can do it. I don't think there's any prohibition against it. And you just say, I confirm that I'm not, reviewing your will, and we're not discussing planning your will in any way. And I'll limit myself to just the power of attorney. I think you can do that. I don't like it because it's not worth it for me to, do it really, except if I charge. For wills, I have no problem actually. I say to them,
Would
look,
just doing just the will, you mean?
yeah, I
Yeah,
write in
okay.
in my conference. So one of the things in the reporting letter is if I don't do powers of attorney for the client, let's say I do wills, but I don't do powers of attorney. Then when I generate the reporting letter, it's going to say, I confirm I've not been retained to prepare your powers of attorney, and you're satisfied. So I don't have a problem with that. I think it's if it makes sense for you to do from a business point of view, then do it. But just make sure it's covered off that I'm not, this has nothing to do with when you die if you're going to do powers of attorney only, and so. And if you want to have them acknowledge it or something, if you want to.
Yeah, no, for sure. And I think more my concern, as I mentioned, is the flip of it rather than the will. It's just the POA, and that's the one where I have more trouble with.
Right. Well, just charge them the way to do your job properly, and then they'll say, well, I can do this online. And you're say, great, go do it online.
Yeah.
And watch the banks reject the document that was done online. So,
okay. Thank you. Thanks for your perspective.
Yeah. 2 copies of reporting letters. No, I just give 1 copy of the reporting letter addressed to both clients. The escrow agreements are done separately, automatically. So one for each client for the holding of powers of attorney. But in this case, I'll just show you, this was the one. It said that it recognized that we weren't doing powers of attorney. So it just says that. So mostly this is helpful, by the way, for your own records. So you can review, like, why can't I find the original power of attorney? Oh, I gave it to the client, or whatever it might be. It's very helpful and reassuring in my experience. So we're gonna give 15 minutes of professionalism and 15 minutes of substantive for this session. And the escrow agreement is automatically generated based on what you documents you're holding. So if you want to just try to generate that through your documents, it's basically, if you click reporting letter and select that you want to include escrow agreements, here's what happens. So it generates that document. I'll just show you for a second where you can find that in case you're not sure. So if you go to reporting letter, we just do it all in the reporting letter. And if you want to include escrow agreements, you can just click that off. So that's that. Well, thank you, everybody. I hope you found that somewhat useful, and I hope to see you guys again next week. If you want to fire away, I'm here to stick around for another 10 minutes. And if anybody has any other questions, happy to see if I can answer them in the next 10 minutes. So, but if you want to leave, so be it. That's great. Thanks again for joining us. Anybody have a question that you want to fire away?
Jordy, it's Alan Friedman.
Hi, Alan.
Do you really think that saying that you didn't get instructions to prepare a power of attorney is enough to protect you, when the client could turn around and say, or somebody who's a beneficiary or family member might say, did you explain to them the importance of having a power of attorney?
And presumably I would say I did. You could add that if you wanted to your reporting letter. It's a rare occasion, quite frankly, where I don't do the powers of attorney, but I think, Alan, you're quite right. If you want to put in your reporting letter, you told me not to do powers of attorney. As I mentioned to you, powers of attorney are very important and could result in legal limbo if you don't have one. Right. Fair enough. That's good. And maybe what we'll do is add that to the reporting letter. So okay. Thanks for that. That's the great thing about eState is we're getting the benefit of so many people's experience and suggestions, and it's a collection of lots of our ideas. So I appreciate any of those suggestions because it just makes it better for everybody. It's a contribution to the bar, and I thank you for it.
Well, I don't have, again, it's Alan. I don't have a question, but I have to tell you, I'm very impressed by all the videos, and we've just joined on, and I'm glad we have. It's quite an eye opener.
Well, thank you, Alan. We're glad to have you on board. Any other questions before we sign off? Well, thanks, everybody. Really appreciate you. Oh, sorry.
There are 2 questions in the chat.
Oh, okay. 2 questions in the chat. Let me see. Say you did a will and a power of attorney for a single client who is married to someone else who did not retain you or wanted to do their will at the time. What do you say when the spouse later comes to you wanting to do their will? How do you change this from a first marriage to a second scenario? Right. So I would say, so here's a situation. You act for wife first. She says, I'm just acting. I just want you to act for me. My husband's got someone else. Great. And then you do their will for the wife. Then the husband comes to you and says, well, now I'd like you to do my will. I think that's a separate retainer. And I'd be a little cautious about that. I'm like, why do you want me to do that will? And, I can't, without the consent of the wife, disclose anything to the husband. So unless I get a new retainer and say, okay, now that's a joint retainer because both of you want me to talk to both of you, then that's a new retainer. But I think your retainer with the wife is over, but you have still the duty of confidentiality and all of that. So that's one of those things. Not sure I'd want to do that. You didn't want me to do it in the first place. I don't know. So, and then there's the issue of acting in a second marriage. And I've talked about that before, but I have some rules about not acting where there are children from prior relationships as a matter of my firm rule. But I'll leave that for another day to talk about. So yeah. The interim letter is great too. An interim reporting letter. I again send the summaries, the graphic summaries and the text summaries, which I use sort of as to help guide the client through their documents. But yeah, an interim one's good. Yes, and honoring, banks that don't honor powers of attorney. Well, I can't control them. I can just do it the best way I can. I mean, that's why I would recommend clients get lawyers to draft powers of attorney. It's more likely that they'll be accepted by the banks. But yeah, I mean, it's a pain. That's one of the reasons I would recommend that you not use a springing power of attorney, that it be effective immediately. It's just one less hassle that you have when you're dealing with the bank. All right. Well, thanks, everybody. Feel free to join next Thursday, and we'll open the floor for comments and questions. And again, have a great afternoon and a great week, and we'll see you again next week.